Welcome to the Savvy Commercial Real Estate Podcast, your resource for relevant, helpful, and immediately usable information regarding all things commercial real estate. Whether you are buying, selling, financing, exchanging, managing, or developing commercial real estate, rest assured you are in the right place. Savvy Commercial. Listen, apply, repeat.
Well, good morning, everyone, and welcome to the Savvy Commercial Real Estate Podcast. My guest today is Steve Donell from Los Angeles, California. In addition to holding the distinguished certifications of CPM, ARM, and CCIM, Steve is also the president of Jalmar Properties and Fed Receiver. Mr. Donell has also administered and or been appointed as a receiver in 900 cases to date, and has decades of experience in receivership matters involving both residential and commercial real estate, asset and business operations, and liquidations, oil and gas partnerships, post-judgment enforcement actions, and the list goes on from there. He has represented the interests of the Securities and Exchange Commission, the Federal Trade Commission, the California Department of Justice, and other government and private agencies and organizations. Mr. Donell is also a past co-president of the Los Angeles Orange County chapter of the California Receivers Forum, or CRF, and is also a current CRF board member and past president of the National Association of Federal Equity Receivers, or NAFER. Needless to say, when it comes to receiverships and frankly real estate in general, it's obvious that my guest today really knows his stuff, as they say. Before we dive into this episode, Steve, perhaps you can tell our listeners a little bit about how and when and perhaps why you first became a receiver.
Acquired commercial and residential property, and the way that we got into receiverships is we acquired an apartment building in Phoenix. We assumed an existing loan, and we wanted to redo the loan with the same lender, which we did. We then sold that property, bought another property in Phoenix, and about a year after that, the lender called us, and this was in the early 90s, and said they had a good experience with us operating real estate, and they expected there would be problems in real estate in the early 90s, and they were looking to make a change with who they used for a receiver, and asked if we'd like to be receivers for the bank since we were no longer borrowers, and there would no longer be a conflict. And we said yes. And that was our first case back in the early 90s and 30 plus years ago and 900 cases ago. So that's how it happened.
Got it. Okay. Well, Steve, in doing the research for this podcast today, I read through, a dozen different publications. I actually thought at one time that I would read a little blurb to you from one of the publications just to kind of set this whole thing in motion. But I thought more about it and decided that, I'd rather just ask you some questions, if you don't mind, rather than try to set the stage with what I found in another publication. So anyway, in no particular order, we're talking about being a receiver. Is it safe to assume that when you're a receiver, you're acting at the discretion or the direction maybe of the court? So would you be a court-appointed receiver?
That's correct. A receiver is always appointed by the court, by a judge, and the receiver is the court's receiver, and the receiver is really known as an arm of the court. So the receiver is doing the work of the court, but obviously the judge is there in chambers, and the receiver is provided with authority pursuant to an order appointing receiver.
Okay, so staying with the court-appointed receivership, I'm sure there are certain duties, obligations, responsibilities you have when it comes to leasing, managing, improving, repairing, accounting, etc. Can you run through some of those? What do you owe back to either the court or maybe the lender or even the property owner? Any or all of them?
Absolutely. Well, first of all, the receiver steps into the shoes of the borrower when the receiver is put in place as what's known as a full equity receiver. Sometimes the receiver is simply acting in connection with the collateral for a loan on a limited basis. But that being said, A receiver owes a duty to the borrower, owes a duty to the property, owes a duty to the lender, and to do the work that the court mandates the receiver does. And that is really the nuts and bolts of the operation of the asset. So that would include risk management, maintenance, leasing, rent collections, repairs, and doing those things that a reasonable owner would do, and also working to comply with covenants and agreements that may exist in the loan documents. And those duties and obligations of receiver are set forth in the order appointing receiver. And if there are some duties or obligations or powers that the receiver wants, but that the receiver was not initially provided with, the receiver can go back to court and expand or modify those powers.
Understood. Okay, so, I know that your duties, if you will, go well above and beyond just those of a caretaker or a steward, if you will. Um, I'm just wondering, do you have the right and the ability, if you see fit to do so, to create any value to improve upon the asset so that it becomes potentially worth more money in case it has to be sold as part of the outcome of the receivership?
Absolutely. I think there's two areas there. Number one, there might be vanilla, ordinary, and customary work that a receiver is doing that maybe the property owner cannot do. There's a reason that the property is in receivership. Sometimes it's underlying litigation with partners, but other times it's because there's a cash flow problem and the borrower is out of money and they can't pay their mortgage. And the receiver is put in place to preserve and manage the property. And so the receiver may have access to cash and funds available, for example, to repair the roof, to pay for tenant improvements, to pay brokerage commissions to real estate brokers, to firm up the rent roll, to solve the problems and repair the substandard conditions of the building that a property owner that is in receivership may not be able to do. So that would be day-to-day operational issues, all of which would tend to uh, increase the value of the property. Then you have an issue involving capital improvements. Generally, if a receiver is going to embark in a capital improvement, such as a roof replacement or a major HVAC replacement, a receiver is generally going to go to court and get permission. That being said, sometimes orders do allow receivers to use their business discretion. So again, it's capital items and day-to-day operations, all of which would tend to improve the value of the property.
Well, Steve, staying with the court authorization for improvements, any CapEx at all, I understand managing, our listeners are going to understand managing a property and hopefully doing a much better job than the previous owner was doing, of course. But now when you start talking about CapEx and other expenditures, let's just assume for a moment that there's not enough cash flow coming in off the property, meaning that, you still have to pay property taxes, you still have to keep the property insured, you have to pay for the day-to-day, what would you call that, maintenance, repairs, things like that, ongoing operating expenses. What if there's not enough money? Well, what if there's not enough money either for those things, day-to-day expenses, or the capital expenditures? Where do you get those funds from? I understand you're going to the court for authorization or permission, but where does the cash come from if it's not there? Could you get it from the borrower, the lender, or somewhere else?
That's a great question. And here's the process. A receiver, either through court order initially or through a subsequent court order, is granted the authority to borrow money. And the instrument that is utilized is called a receiver certificate. And that receiver certificate is essentially a substitute for the note. And a receiver then can borrow money either through the lender, and the lender can do an advance on its existing note and deed of trust without a certificate, or sometimes lenders actually want to have a receiver certificate issued. If the lender is not in a position or does not have an interest in advancing funds, for example, maybe it's a loan servicer and they simply cannot advance funds, then a receiver can go out to a third-party private lender, and we typically pay a premium for the money. But here's what's interesting. When a receiver borrows money through the issuance of a receiver certificate, the new money has a super priority lien over all existing debt and encumbrances, with the exception of property taxes. So if there's an existing first deed of trust, a second deed of trust, or a third, all of the existing debt on the property is subordinated to the new money that comes in through the use of a receiver certificate. And that's very compelling for lenders that want to loan money to receivers.
Well, okay, that to me sounds almost like I would liken that to almost like a bankruptcy situation where you bring in, there's a term they use, you probably know it, where you bring in a debt that's superior to all the other debt except for property taxes. But since there's probably a lien in place, let me just I'll pick on someone, Bank of America. Let's say Bank of America is in first position. Do you have to go and they may or may not have been the one who asked you to be the receiver? You said the court hired you. So in the case of Bank of America, since they're in first position, do you have to go and get Bank of America's permission to put a loan on there that's going to be superior to their loan, or do they just not have much say in the matter?
They definitely have say in the matter. Oftentimes, if a first loan is subordinated, that could constitute an event of default. So what a receiver does is picks up the phone, talks to the lawyer for the lender, explains the situation. And I have done this time and time again where I explain to the lender, look, you have an opportunity to advance, and if you choose not to, outside financing is going to need to occur, and the money is going to be used to prop up, repair, and maintain the collateral for your loan. And oftentimes the lenders understand that the reason that the money is being used is again going to be inured to the benefit of the collateral for the loan. But it would be absolutely important and imperative for a receiver to coordinate and communicate with that lender. I have had situations where lenders have objected, and the court has equitable powers. And I have had situations where courts have allowed me to borrow money from third parties and then have further restrained the ability for the lender to initiate a foreclosure action or to call an event of default due to this new financing. That is not common, but in some instances it has occurred. So it's just a matter of coordination with the existing lender and trying to keep things as friendly as possible.
So you hit on something very, very important, and that is that the existing lender does have, I guess it's like a right of first refusal, if you will. They can add, let's just, again, I'm making this up. Let's say there's a $3 million lien against the property now, and you determine it needs $500,000 in CapEx, capital expenditures, capital improvements, etc. That lender does have sort of a first right of refusal to advance another $500,000, and I'm assuming that makes their lien $3.5 million.
That's correct.
Still in first position.
A first right, but they're the logical choice. They're the logical source for the money. And so receivers are generally going to go to the existing lender to see if they want to advance those funds. And they certainly would have the right to do so pursuant to the loan documents. But keep in mind, I'm not always put in as a receiver due to a default on a loan. There may be a lawsuit with partners where there's fraud that's being alleged, or maybe there's a judgment. And I'm put in place to collect on a judgment where the loan is current, and the lender may not want anything to do with advancing additional funds, or maybe the lender is not an institutional lender. Maybe the lender is the seller that had carryback financing, or is an entrepreneurial lender, or it's a securitized loan where there's a servicing agency and or entity, and they simply are not in a position to advance at all. So every situation is very, very unique.
So I think that's fascinating. If you took, as a percentage, instead of saying out of every 100, I'll just say out of every 10, out of every 10 receiverships that you take on, what percentage would you say is on behalf of a lien holder or first lien holder, or maybe on behalf of someone else, like you said, in the case of a judgment or partnership dispute or something. What percentage of every 10 receiverships is for someone or some entity other than the first lien holder?
It really depends on the economy and where we are in the real estate cycle. When times were really tough, for you and your listeners that are old enough to remember the real estate market in the 90s, it was a really, really tough time. And the numbers were very, very large as a percentage. And then we had 2008, 9, and 10, tough times there. And now we're getting into a period of obviously increased mortgages and increase in defaults. And so those numbers are coming up. So I would say that during periods of strong economy, low mortgages, and low defaults, the percentages are probably only 10 to 20%, where a lien holder has sought the appointment of receiver, and the vast majority of my cases relate to a government enforcement action, a judgment creditor, or underlying partnership litigation. But however, I am seeing an uptick, and it just started within about the last 6 months, where it's called a rents and profits receivership, where a borrower has defaulted on their loan and the lender wants to seek appointment of receiver. And so those numbers are coming up. But for the last 15 or so years, it's been a relatively low number because there have been a relatively low number of defaults in commercial real estate.
Understand. All right, let's kind of switch gears just a little bit and talk a little bit about a sale of the property. This might be a little bit out of order, but you've got my curiosity piqued, and I'm sure some of our other listeners. Let's pretend it's time to sell the property. Is that going to be typically on behalf of the lender, the court, some other party? Who would direct you to sell a property more often than not, and why, if you don't mind me asking you that?
Well, the authority to sell is always going to be contained in the order appointing receiver. However, just because the receiver may have that authority does not mean that the receiver, in fact, will sell the property. Right now, for example, I have an apartment building in Los Angeles where the lender discovered that there was an additional debt recorded against the property. And originally, I was going to sell the property, and the borrower cross-collateralized the asset without the lender's permission. And because of that, there's not enough equity in the property to satisfy all the debt. So in this case, the lender's going to foreclose and wipe out the subordinate debt to their loan. But in many other cases, lenders will not want to take title through a foreclosure action. The loan may be current. It's just that one owner is fighting with another owner, and they want the property sold to be bought out of their position. And so the authority to sell is always coming from the court and is always coming from a court order. And the receiver may not have the initial authority to sell, but may have to go back into court and obtain that authority to sell. And the sale is always subject to court confirmation. And there's a very specific process and procedure by which a receiver needs to comply. And there's also the issue of a private or a public sale. So it gets very, very detailed and specific.
Well, okay. Now, sticking with a sale, if a lender, and I guess we're going to stick with a lender authorized sale. If a lender authorizes a sale through a receiver, would that lender typically save on overall expenses and costs? And if there's no cost savings, is there a time savings as opposed to, as you mentioned, a trustee sale? Is there a time and a place to use a receivership sale versus a trustee sale?
Absolutely. And the ability for a lender to foreclose is going to be subject to the statutory schemes set up on a state-by-state basis. Some states allow for foreclosures to occur relatively quickly. Other states, it can take a much longer time period. And so, especially in states where foreclosures take a lot longer to accomplish, there would be an enormous time saving for a receiver to sell the property. In addition, if a receiver sells, the lender is going to save obviously on legal fees and is not going to have to go through that foreclosure process. The other interesting thing here is that a lender is just that, a lender, if the property is sold out of receivership. But if a lender ultimately forecloses, they are going to become an owner and they will be on that chain of title. And oftentimes, especially when there are environmental concerns or ongoing litigation, a lender may not want to be on chain of title. They may not want to be an owner. They may want to only have an interest as a lender. And so there may be non-economic reasons that a lender wants a receiver to sell, for example, avoiding the exposure to environmental contamination.
Okay. Okay, so I'm looking at I'm looking at my outline, some of the questions that I had.
Recording in progress.
And you've answered a lot of my questions, but I'm going to ask you a question that, if you've already answered it, then my apologies. But can you just go back to the main difference between a foreclosure sale or a trustee sale and a receivership sale? There are some similarities from what you said, but can you tell me where those are distinctly different?
Sure. Well, there's definitely a difference. Some states, for example, California, you have a trustee. So you have the borrower, the lender, and then a trustee. And ultimately, the trustee is vested with the power to sell through a deed of trust. Or you might have a mortgage state where it's just the borrower and the lender, and there is not the third party trustee. That being said, a foreclosure sale involves a notice of default, publication of that notice of default, and then perfecting the process, culminating with ultimately either a trustee or a foreclosure sale. And then there would be a bidding process at that foreclosure sale. And assuming the lender is the highest bidder and they can effectuate a credit bid, there may be other bidders at the foreclosure sale, but somebody's going to buy that property at the foreclosure sale. And then that buyer then becomes the owner of the property. A receiver sale does not involve a foreclosure. So in that instance, the receiver actually signs the deed. The receiver is the seller, and the lender is going to get paid off through the escrow process. And they'll either get paid off in full, or sometimes the lender is going to have to take a haircut and they're going to discount their payoff, but they will not take title. So it's either a foreclosure or a receiver sale, one or the other. And in the instance of a receiver sale, again, the lender does not take title to the property.
Well, that's fascinating because I've attended lots of trustee sales over the years, and in fact even represented some buyers. And the lender always assumes the risk of nobody bidding, and they end up taking the property back, which means they step into the chain of title. So that's interesting. In a receivership sale, they don't have to worry about that. Well, there's another interesting aspect of trustee sales, and that is that those have to be posted or noticed to the public for a period of time. There's got to be usually in Arizona anyway, a 90-day period between the notice of default and the actual sale. But in a receivership sale, are you required to publicize that? How do people find out about a receivership sale? Or is there a chance that you're going to hold a receivership sale and nobody's going to show up because they didn't know about it?
If I did that, I wouldn't be doing a good job. If I held a sale and nobody knew about it, shame on me.
Okay.
A receiver is to use his or her best business judgment, utilizing those skills that they have in order to sell property. And almost all receivers are going to have a level of experience in managing and operating real estate as well as selling real estate. With respect to publication, if a receiver is appointed in federal court, there are very specific rules in federal court, and a receiver will be ordered to sell either through a private or a public process. If the receiver sale is done through the public process, there is a notice requirement. There has to be a publication in a newspaper. If it's a private sale, then there's a requirement for appraisals and not selling less than a percentage of the appraised value. And the court can fashion the manner of sale how the court wants to do so. But it's very, very specific and relatively rigid in federal court. If it's in state court, that is going to be subject to every state court's statutory scheme, and most of the states do not get quite that specific. So then it goes to the custom and practice of the receivership industry and the custom and practice of the receiver. A well-qualified, competent receiver is going to market the property, is going to hire a third-party broker, is going to advertise, is going to use many of the traditional sources of online advertising, emailing, websites, etc., to try to garner as much interest as possible, to then get competition and bid up the price as much as possible. And then there will be maybe a final call for offers, ultimately with the receiver selecting a buyer. And then the receiver is going to go to court and seek to confirm the sale with a particular buyer. Here is the unknown. Sometimes a receiver sale is going to be subject to overbid, and sometimes it's not. And that's going to be subject to the way the court wants to do it. And sometimes the owners of the property may weigh in and say, no, they want an overbid process. If there's an overbid, you have your initial buyer, and that's known as the stalking horse buyer, and that buyer goes under contract subject to an auction or an overbid process. If that initial buyer is overbid, oftentimes they'll get a breakup fee. So the fees that they've incurred are returned to them, and there will be an incremental increase in purchase price based upon this overbid process. So it's subject to statute, and it's subject to the way that the receiver seeks to set it up, and it may be up to the way a particular judge wants it done, regardless of what the receiver wants.
So I think that's fascinating. When you go to a trustee sale, if somebody bids, and as long as they come in with the money, and here in Arizona it's 5 p.m. the next business day, so as long as they come in with the money, that sale is final. So are there situations where a receivership sale is not final, or did you say that it is actually a final sale?
It would generally be a final sale. However, there's two issues. Number one, many states have an appeal period where certain types of court orders can be appealed. In California, for example, a state court order is appealable within 60 days. Therefore, when a receiver receives an order confirming the sale, generally, in order to get title insurance, the title insurance company is not going to provide a title insurance policy until the appeal period has expired, which would be 61 days after the order after the order approving the sale has been signed by the judge and distributed to the parties. But if there's an appeal of that order, then the sale generally cannot go through until the appeal is handled. I have also seen situations where an order has been signed by the judge approving a sale, and then a day or two later, another buyer comes in and offers a substantially higher amount of money for the property. This is unusual, but I have seen it in the past where they might try to intervene in the litigation, and the court has equitable powers. And I have seen situations where the judge would unwind that first sale and allow another overbidder to buy the property after the court has already approved the sale. That would be very rare, and there would have to be some very, very unique circumstances. But other than that, yeah, I mean, I've sold well over 100 separate properties through a court process. And actually, none of my sales have been subject to appeal, and none of my sales have been subject to being reversed. But I am aware of other situations where that has occurred, but it's very rare.
Actually, that was my next question, but you answered it. I was going to ask you, how common that is, but it sounds like it's not common at all. Steve, I want to just take a quick break here before we get to our last questions and ask if you could share with our listeners, your name obviously is Steve Donell, but could you share with our listeners, your name, your firm's name, and your phone number and your email address, if you don't mind, in case someone hears this, especially if they're a lender or they have the potential to hire a receiver. I'd like for them to know how to get a hold of you.
Sure. Again, yes, my name is Steve Donell, and I'm president of Fed Receiver, and my direct line is 310-689-2175. Our website's www.fedreceiver.com. And my email address is steve.donell, Donell, at fedreceiver.com.
Got it. And I'm writing that down too in case anyone reaches out to me and asks me. Okay. So back to we're down to the back end of our backside of our questions here. So in preparing for this and doing a lot of research and so on, I saw two terms. I'm sure you're very familiar with them. One is a general receiver, and the other is a limited receiver. Could you tell our listeners what the difference is between those two?
Absolutely. Let me use a piece of real estate as an analogy. Let's say that there's an office building and it's located at 100 Main Street. And the property is owned by an LLC called 100 Main Street LLC. The property is worth $10 million, and there's an $8 million loan on the property, and the borrower, 100 Main Street LLC, has defaulted on the loan. And there's just simply a loan default, no other problems. In that instance, the lender will want to appoint a limited purpose receiver only to take possession of the real property of the building and ultimately to manage it and preserve it and maintain it until such time as either the lender forecloses or the receiver sells the property. Or sometimes the borrowers actually can find money and bring the loan current. That is a limited purpose receivership, also known as a rents and profits receivership. Let's then use the same building owned by 100 Main Street LLC, and let's say that 100 Main Street LLC is itself owned by 5 partners, 5 members of the LLC. And the managing member of the LLC actually diverted millions of dollars from other LLCs to acquire this building. And the other investors find out about it and they file a lawsuit against the sponsor or the managing member of the LLC. In that instance, they would want the entity itself to go into receivership. And in that instance, a full-blown equity receiver would be appointed over 100 Main Street LLC, and the assets of the receivership would include the office building in my example, and it would also include the ability to handle all litigation for the entity, to file the tax returns for the entity, to take over all the books and records of the entity, and also to seek clawbacks and initiate additional litigation on behalf of the creditors of that LLC. So in one instance, it's limited, where the receiver only takes possession of the real estate, or an equity receiver is where the receiver takes possession of the entity itself and literally steps into the shoes of the owners and handles all of the taxes, all the books, all the records, and even takes over their office and can change the locks of the office itself of the owner.
Okay, well, I don't think I would be doing my job if I don't ask the obvious question. How often are you retained for a general receivership, and how often would you say you're retained for a limited receivership action if you track such things?
I would say about 20% of my cases involve the equity receiverships, and about 80%, rough numbers, are on a limited basis. But I do a lot of very, very complicated partnership disputes, which involve forensic accounting, and then also the government enforcement cases with the FTC and the SEC and state agencies. Those always are equity receiverships, and there may even be criminal conduct involved. And in those instances, there could be agents with the Department of Justice and the FBI involved. So the majority of the cases are limited, but in sheer numbers, I mean, I've handled well over 150 equity receiverships over many, many years.
Wow, that's a lot. Okay. Well, let's leave California just for a moment. I know you're based in the LA area, but I'm sure there are other states outside of California where you handle receiverships. Is that correct?
Absolutely. Yeah, I've handled cases, I think, in about 12 different states, and I've had assets up in Canada, Mexico. I had one case involving assets in Turkey, Italy, all over the place. I was actually appointed through the Court of Queen's Bench up in Canada as a receiver in all Canadian provinces, and I took possession of assets through a Canadian court as well. So I've had cases in state and federal court with assets throughout the country and assets filed in different states. The majority of our particular cases have been in Nevada, Arizona, and California. I'm a broker in all three states, or our company is. But I've had cases originating in, again, I think in about 13, 14 different states.
All right. So, what if someone approached you, a partnership, a lender, etc., and the asset was in another state that perhaps you don't want to be involved for whatever reason? It's too far away, or you're too busy, or what have you. Do you have a network of receivers around the country where you might refer that business to another receiver? Does that ever happen?
Absolutely, yes. The National Association of Federal Equity Receivers, or NAFER, is an organization, a trade organization for receivers across the country. And we refer business to each other all the time. I'm actually working for a bankruptcy trustee based out of Florida, and there's 15 different properties here in California, and I'm acting as her kind of boots on the ground. It's not a receivership, it's a bankruptcy, but that trustee is part of NAFER as well. And then through the California Receivers Forum, and there's some other trade organizations for receivers, we all refer business to each other. And, one minute we're competitors, and the next minute we're working with each other. So it's a relatively small network of folks, but we try to support each other and work with each other. And NAFER is certainly an excellent resource for that.
Okay. So I don't mean to put you on the spot, but I also would never want to be accused of not asking pointed questions. So I'm going to ask this question. Are there ever occasions where there might be a disadvantage to a receivership action? Or maybe another way to phrase that would be, are there sometimes advantages versus disadvantages? And can you go through a few of each?
Certainly, I think initially the disadvantages to a receivership would be cost. I bill by the hour. I have staff here that bills at lower rates. So generally, receivers are always going to bill by the hour, and depending upon the complexity of the case and the level of cooperation or lack thereof, the fees are going to be higher or lower. If the amount of money in dispute is not particularly large, it just may make sense for a lender to foreclose. Or if there are no rents to protect or to collect, or there are no problems with the building. Look, if it's an empty industrial building and the property is secure and there's no issues of concerns about security or vandalism, and the lender has put forced place insurance on it, there's really not a great deal of reason to have a receiver appointed. Unless there's environmental issues, that may be a good reason. So I would say that the asset has to be large enough, or there needs to be income that the receiver would need to obtain or grab and protect for the benefit of the lender. But if there's no income and the amount in controversy is not great enough, probably doesn't make an economic sense. But that being said, I think that the advantages of a receiver involve the collateral for the loan. Is there waste? Is there a diminution in value? Are there risk factors? I have a car-centric retail center, and the tenants were disposing of oil and other chemicals improperly, and that was going into the ground, and that is impairing the value of the building because the loan is on the building, which sits on the land. And that was one of the first things the lender wanted me to do, was get in and get a handle on the environmental issues. So it really comes down to the physical condition of the property, the source of income, the risk tolerance that the lender has, and whether or not the amount in dispute is large enough to justify the fees of the receiver.
Great answer. Great answer. I thought about that question, and I thought that it's not always rose-colored glasses, so to speak. Sometimes there's got to be some potential downside, and you touched on that. So thank you. Again, Steve, going back to some of my research in preparing for this podcast, I came across the term Uniform Commercial Real Estate Receivership Act, or UCRERA, which I'm sure is also in your lexicon. I'm sure you are very familiar with that. Why might that act be important to either a lender or a property owner?
Sure. Well, I don't know that it would be particularly important to a property owner, but it would definitely be important to a lender and to lawyers representing lenders. The Uniform Commercial Real Estate Receivership Act, or UCREA, is relatively new, and I believe at last count there were 13 or 14 roughly states that have adopted the act. Arizona recently adopted a portion of the act. And uh, what the Act does is it provides a consistent and uniform set of powers and procedures that a party, typically a creditor, will utilize in order to seek the appointment of receiver. And the Act authorizes the receiver, without further order of the court, to do a number of things, including to operate the business, to sell the property, and it also provides for a litigation stay, which is a bit unusual. Most of the state court cases I've been involved in generally don't have a litigation stay, and this is similar to bankruptcy. But the Uniform Commercial Real Estate Receivership Act does have a litigation stay. It also provides for quasi judicial immunity for the receiver, meaning that if somebody wants to sue the receiver, they have to get the permission from the court to do so. And it also sets up the procedures whereby a receiver can get paid and how a receiver can get paid. Some states, such as California, Arizona, Nevada, Illinois, there's a couple of states out there in Wisconsin that have a very deep body of procedure and law and statute regarding the appointment of receiver and how receivers operate. Other states, it is very slim and it's kind of the Wild West. So this provides the statutory scheme by which a receiver can be appointed on a consistent basis, especially for those states that don't already have a deep body of statutory schemes that have been created.
Okay. Okay. Thank you for that. I'm going to switch gears a little bit for the last few questions. You were talking about earlier a potential sale of a property that you're the you're the receiver on. So this is kind of a percentage question again. In what percentage of the sales and leasing that you do you hire an outside broker to do those things versus what? And let's throw in, make it three things: a sale, a leasing assignment, or a property management assignment, right? Because all three of those things probably have to continue to be done in most cases. Not all cases, but most cases. In what percentage of your receivership, Steve, would somebody be hired, an outside third party, be hired to do those things? And what percentage of the cases would you do those in-house? And the second part of that would be if you're hiring, so like in a bankruptcy, for example, an attorney would have to go to court to get permission to hire those people. It's probably not that difficult, but you have to do that. In a receivership action, if you wanted to hire an outside third party, do you have to go and get permission, or because you already have the receivership order, that's already granted in advance? So it's a twofold question.
Yeah, great question. As far as employment of professionals, and that would be the term employing professionals, which would include lawyers, CPAs, brokers, property managers, sometimes a receiver is provided with the authority to do so in the initial order and is given blanket authority to do so. That would be much more common in an equity receivership case. However, in those instances where a court order or the order appointing receiver does not provide the receiver with the authority to employ professionals, a receiver would need to file a motion with the court to seek to employ those professionals, whether it's a leasing agent, a broker, a real estate broker to sell the property, or a property manager. Since I happen to own a property management company, probably about 75% of the receiverships that I get, I use my own management company, and it really provides a level of efficiency. However, if my company is not the one best suited to manage the property based upon either property type or location, I would then utilize a local third-party property management company. As it relates to leasing and brokerage, although I am a broker, that is not our forte. It's not what I do day to day. So in 95% of my cases, I end up hiring an outside leasing agent and or brokerage firm to list and sell the property. I do have some lenders that really want to just deal with me, and they don't want to deal with an outside brokerage firm. And in a couple of cases, I've done a co-brokerage deal with brokerage firms because the lender just wants my name on the dotted line. But the vast majority of the receiverships that I handle, I use an outside third-party leasing and brokerage company.
Okay, got it. So any commercial real estate brokers who might be listening to this might be well served by reaching out to receivers in their area to get their name on the list, I guess. Um, I have only a couple more questions for you, and the first one is another multi-part question, but it all ties together. Have there ever been any situations in your experience or in your receiverships where an asset has multiple parcels? And I'm thinking maybe in terms of maybe not an apartment building per se, but let's say a retail center. You have, 5 or 6 separate parcels, but maybe the debt can be satisfied by only selling part of it. Let's say you have a shadow anchored space in a shopping center and it's one of the 5 or 6 parcels, and you've made a determination that by selling that, you could satisfy either the entire loan or enough of the loan so that there would no longer be a default, and maybe you don't have to sell the entire shopping center. And the second part of that would be, and again, this could be maybe the property is appreciated since the loan was taken out or for some other reason. But if such a thing would ever happen, could you potentially sell a portion of the asset, satisfy the debt? Maybe that cures the reasoning for the receivership. Let's say in this case it does. And would you then turn back the remainder of the center to the borrower?
I haven't had a situation where a commercial property, where I ended up selling a portion of a commercial property. But what I have seen is situations where I've been appointed as receiver over numerous parcels of vacant land. I've also been appointed as receiver in connection with partially constructed single-family homes, for example, and then vacant lots that are partially improved or that are going through the entitlement process. And just exactly as you've identified, in a period of appreciation where time is with me as the receiver and with the property owners because values are going up as opposed to going down, time is helpful. And I have had situations where I have only had to sell a portion of the parcels of land in order to satisfy the debt, and then I've obtained a reconveyance. And indeed, that would then satisfy the obligations of the receivership, and the parcels go back to the owners. I haven't had a situation though where there'd be an out parcel or a pad that was left on its own because that again gets a little bit messy with separate ownership anyway. There's also the issue of guarantors. And what exposure do the guarantors have, and what is the specific security for the loan? So I've had situations where a guarantor has had exposure on one property that I'm the receiver on, but they're also the borrower on another property, and they're very, very concerned about whether or not I'm going to pay off and satisfy the existing debt. And in those situations where I'm unable to satisfy the debt, the lender then can have the option to pursue the guarantor. There are issues involving the one action rule, and I don't want to get too in the weeds here, but lenders may or may not be precluded in pursuing deficiencies. But it's very case specific. But I do have one specific case in mind where I was able to only sell a portion of the parcels to satisfy the entire debt encumbrance.
Okay, thank you. Now, Steve, this last one I kind of just threw in there since we started talking this morning, and and that's because it just came to me because of something you said earlier. But in the current market that we're in the current environment that we're in, we have loans maturing all over the place. I mean, you can't pick up a Wall Street Journal, Barron's, go online and, Globe Street, CoStar, whatever, without reading something about the volume of maturing loans this year, next year, the following year, and so on. If you read those things, you also hear about debt service coverage ratios, higher interest rates. If somebody bought a property a few years ago and financed it at 3.5%, I'm just making that up, especially if it was an adjustable rate loan, they're no longer paying 3.5%, and they could be experiencing some pain right now. So might the lender, as a matter of fact. Are you getting a lot of calls, or are you getting a lot of business these days from these types of situations? I don't think a lot of this was projected to happen, let's call it 2-3 years ago, but the pendulum always swings back the other way, and in this case, I think it has swung back the other way. So, as a category, I don't want to say distress, that's so overused, but as a category, is this something that would keep receivers maybe a little bit busier, or make receivers a little bit busier than they might have been a year or two ago?
It absolutely, that is absolutely true. And, there's two primary types of defaults. There's either going to be a maturity default when a loan is due and payable, or there's going to be a default in the middle of the loan where the borrower has run out of cash flow. And that primarily is going to be as a result of a variable rate loan. I had an office building here in north of Los Angeles. It was an SBA loan, and the loan doubled in a relatively short period of time, and the property simply didn't have the cash flow available. And so I was put on as receiver, and I sold it as the receiver. I'm also, interestingly enough, I have 4 pending receiverships. I had expected to see more office buildings, and I haven't seen as many office buildings, but I've got 4 pending apartment buildings. 3 of the 4 apartment buildings are maturity defaults, where the loan is due, the borrower has not been able to sell the property enough to pay off the debt, and has not been able to find replacement debt because of how much higher the mortgage rates are today than they were 5 to 7 years ago when the mortgage was originally funded. And I have not seen maturity default receiverships for over a decade, and they are coming back. So yes, us receivers are getting busier. And we are seeing both maturity defaults and then defaults as a result of an inability to keep the loan current due to variable rate loans.
That's fascinating, and I don't know. Me personally, I think we're kind of at the early stages of that, which means that again, as a category, you're going to be in for a ton of activity over the next few years. I think we're just at the early stages of this. That's just my opinion. Well, look, Steve, I appreciate you coming on today and sharing your wisdom with us. It's incredible. I want all of our listeners to know once again, our guest today has been Steve Donell, who is the president of Fed Receiver. And although based in Los Angeles, he has handled receiverships all over the country and in actually other countries, Mexico, Canada, and so on. You can reach Steve at either 310-689-2175 in Los Angeles. You can send him an email at steve.donell, and that's 1N, Donell, at fedreceiver.com, Fed short for federal. And if you want to check out his website, go to www.fedreceiver.com. Steve, once again, thank you for everything. This has been unbelievably informative and eye-opening. I'm sure all listeners are going to say the same thing. And again, thank you. And hopefully we can have you back down the road and see how things have changed, maybe later this year or early next year, to see if this last thing has come true with the pendulum swinging back the other way.
Neil, thank you. I appreciate the opportunity, and be delightful to come back.
Well, thank you. Appreciate it. And have a great day. Take care.